seconds. Good evening, everyone. Welcome to our Lishan Talk webinar. This evening, we are very honored to be joined by Charlotte Tregunna of Peters & Peters. Peters & Peters is an elite boutique law firm in London that focuses on white-collar criminal as well as sanctions-related advisory and litigation matters. We're very pleased tonight to have Charlotte join us and to give us an introduction or overview of general principles of UK corporate criminal liability. So with that, Charlotte, I'll turn it over to you and let you further introduce yourself and Peters & Peters, as well as your topic for this evening.
Lovely. Thank you so much, Robert, for that kind introduction, and welcome everybody to this webinar on general principles of UK corporate criminal liability. As it says, my name's Charlotte Tregunna. I'm a partner in the business crime and investigations team here at Peters & Peters Solicitors in London. We are a firm, as Robert just said, a boutique law firm specialising in white-collar crime and investigations, but also our other side of the team does commercial litigation and asset recovery. Now, we act for corporates and individuals in all areas of our practice, wide range of expertise, as Robert mentioned, sanctions, export controls, but also in areas such as fraud, bribery and corruption, cybercrime and data theft, along to our more international focus work of extradition, mutual legal assistance and Interpol work. We also do tax investigations and prosecutions, and then on the commercial litigation side, international arbitration, insolvency and bankruptcy. And probably more pertinent for this topic, we also help corporations with preventative compliance programs. So just in terms of, I've just popped our contacts up on there, and I'm sure you can look at them on the website, our website, but I just mentioned Michael O'Kane, who is our senior partner. Now, he will be one of the trainers at the Global Compliance Management Masterclass between the 19th and 21st of July 2024. And the topic today really is intended to be a theoretical look at corporate criminal liability in the UK, including what I'll describe as the failure to prevent offences, whereas Michael, during the training, will be providing more practical training alongside a case study with a focus on what Chinese corporates can do to protect themselves and their subsidiaries from committing these offences, focusing on how to make your compliance regimes and policies and procedures more robust and in line with changes in the law that I'll come on to later. Just in terms of Peters & Peters and our involvement in SIPAC, we've been a member for nearly a year now, and we're very excited and very proud to be part of this fast-growing and incredibly important organisation. As I mentioned, Michael will be one of the trainers at the masterclass in July, and both Michael and I will also be speaking at the second annual Sino International Law Forum in Shanghai between the 14th and 15th of November. I think I got that right, Robert. And we spoke at the last forum in 2023 and made some wonderful connections. And we look forward to seeing you there and to meet again those that we met last year. Very briefly, I know this looks like a very intense slide in terms of our experience, but I just wanted to point out a few of the cases that we have been working on in the more recent years in terms of corporate criminal liability experience. We act for corporates. We also act for lead suspects or individual clients in various different guises in different types of case. I mentioned a couple there. So the oil and gas company MOL, we acted in a major dispute with Croatia involving domestic criminal liability, international standards for criminal investigations and prosecutions. And then on we act for banks, we act for major multinationals in various different sectors. And then in terms of individual clients, we've acted for some of the lead suspects, I would say, the lead individuals or protagonists in some of the biggest cases in recent years. So I mentioned 1MDB, which both Michael and I worked on. We acted for a lead suspect in one of the biggest corruption investigations, worldwide corruption investigations in recent times, the misappropriation of funds from the Malaysian Sovereign Wealth Fund 1MDB. And then we've acted for various different senior executives, Richard Bothe in the Barclays litigation and the Serco litigation, and a prominent trader in the foreign exchange and LIBOR investigations. So that's enough about us. I'm sure what you're interested in more is the agenda for today. So I've set that out on this slide. So we'll go through the general principles of corporate criminal liability, the various different ways corporates can commit offences in this jurisdiction. I'll go on to what we call the identification principle or the identification doctrine. Now, this has had huge change. It's some of the biggest reforms in corporate criminal liability in the UK for many years, at least 20 or so years. And so it's very important that you're aware of these changes and how they might impact corporations, not just in the UK or if you have a subsidiary in the UK, but overseas as well. I'll then move on to what we are termed, it's a rather odd construction of language, but the failure to prevent offences. Now, some of these I'm sure you are fully aware of. The Bribery Act 2010 has been in legislation on the legislative books for over 14 years now. The more recent Criminal Finances Act 2017 introduced the failure to prevent the facilitation of tax evasion, and very, very recently, probably the biggest reform for and the biggest introduction of the most wide-ranging offence in the Economic Crime and Corporate Transparency Act 2023, the failure to prevent fraud. Now, throughout this, I will be interchangeably, it's a very long named act, so I hope you don't mind that I will be referring to it as the ECCT Act rather than the Economic Crime and Corporate Transparency Act, but I hope that you will know what I'm talking about during the course of this webinar. Then crucially, I think for you, the jurisdictional angle, the extraterritoriality of all of these three offences and corporate criminal liability more generally. Can Chinese individuals, can Chinese corporates be liable? And then finally, briefly, I'll touch upon what do you and your business need to do. I should say, I think Robert will be taking questions throughout. I think we're going to the end of the webinar. We will be taking questions rather than throughout. I hope that's okay for you, but do please send Robert anything on WeChat if you have any questions throughout the course of the webinar. So, general principles of corporate criminal liability. So, a company is treated in the UK. Oh, I should also say I refer to UK law here. It's technically incorrect, but it's much easier to refer to UK law. Obviously, I only operate in England and Wales. It's much more difficult to say English and Welsh law all the time. So I do refer to UK law, but it is technically incorrect. Scotland is a separate jurisdiction. Northern Ireland is also a separate jurisdiction from a legal perspective. So it is England and Wales law that I'll be talking about here, although there are lots of similarities in Northern Ireland and Scotland. And if you wanted to know more about that, please let me know. I know lots of Scottish and Northern Irish lawyers who could assist with that. But I will just refer to UK law again for ease. So a company is treated in UK law as a legal person, and they are capable, therefore, of committing and being prosecuted for certain criminal offences committed by those acting on its behalf. So there are three fundamental ways in which a company commits a criminal offence. Now, that's through what I mentioned earlier, the identification doctrine or the identification principle. Now, historically, that's when a person can be shown to be the directing mind and will of the corporate. And then if they are the directing mind and will of the corporate, that corporate can also have committed an offence. But as I say, there have been some significant changes to this area as a consequence of the ECCT passed last year. And the second way is where Parliament has created specific offences for corporates. So that includes these failure to prevent offences, which we will be delving into later. And then finally, a little bit of overlap, but through vicarious liability, which is a very well understood and known rule of law that holds a company or a person responsible for actions committed by their employees or other third parties, generally used for regulatory offences that perhaps don't require proof of fault, known as strict liability offences. So the identification principle, or sometimes referred to as the doctrine, why has it changed? Well, when it came to prosecuting companies, and this has been a huge criticism of the main law enforcement bodies for corporate criminality, the Serious Fraud Office, Financial Conduct Authority, when it came to prosecuting those companies for serious financial crimes, the identification principle was considered to be outdated and ineffective, and had been criticised for failing to keep up with the evolution, really, the breadth and nature of business in the 21st century. Now, while debating the ECTT Act, so then the bill, the House of Lords said that companies have grown, their operations and governance has become spread across different areas, and it's making it very difficult to pinpoint the directing mind and will of a company, particularly in those large organizations. So they found that individuals who had significant authority could escape themselves and corporate liability by asserting that the actual directing mind and will is elsewhere. They felt that was actually unfair to smaller companies, perhaps with one or two directors, where it was much more identifiable who the directing mind and will was of that corporate. So smaller companies were more likely to be convicted of a corporate offence. Bigger companies who arguably might have more impact when they do commit a bribe or when they do commit fraud. They were being less likely to be prosecuted and less likely to be convicted. Now, why is this important? Why are big corporations getting away with it? Why is that a big problem? Well, in the Crown Prosecution Service, so the Public Prosecution Service in England and Wales, stated that the scale of fraud of UK presents 40%, and this was some time ago now. It's probably even more so now, probably 60% of all criminal activity. So it's hardly surprising now that there has been a legislative shift on focusing on holding corporates, not just individuals, but corporates, to account for their criminal behaviour. And that shift has seen the change in the identification principle I'll come on to later, and of course the introduction of more of these failure to prevent offences. So I will go into all of those in a second. The other thing that I just wanted to point out in terms of why these have been created, I mean, as I said before, they are the biggest, largest and most meaningful change to corporate criminal liability in decades. And it will have, or the hope is, I suppose, that it will have a transformative effect on our ability to hold corporates to account for the actions of its individual actors, associated persons and employees, the definitions of which I'll come on to later. Just a little bit more about why this has changed. So Lord Garnier, who I'm sure some of you will know, he was the former Attorney General some time ago. And as an aside, during his time in office, he supported the introduction of the Deferred Prosecution Agreement in the UK, the DPA, for corporates, in which corporates can reach an agreement with a prosecutor where the company is charged with a criminal offence, but proceedings are suspended for a defined period, allowing the organisation to meet certain criteria of the Deferred Prosecution Agreement. So Lord Garnier, distinguished the identification principle and the failure to prevent offences in the House of Lords as follows. He said, "We must recognise the distinction between the identification principle and the amendment that the government is bringing forward, which enables people lower down the corporate hierarchy to bring liability for criminal activities to the company. That's to be distinguished from the failure to prevent regime, which is where the company is made liable for failing to prevent offences committed by its associates or other employees, sometimes overseas." And that's why I thought this was very important for overseas corporates and individuals, particularly in China, to understand how this can affect and how these changes in the law can affect now a broader range of overseas companies and individuals. So, identification principle. the historical situation. I mentioned it earlier, but it was previously under the common law provisions, so not a legislative change, but a company could be held criminally liable if it could be established that an offence had been committed by an individual who had the relevant mental element of the offence, the mens rea, and was sufficiently senior within the corporate that it could be said that they were, as I said before, the directing mind and will. Now, who is the directing mind and will? This could be board level executives, CEOs. It was really the upper echelons of a corporate. But as we have seen, government and prosecutors had been very critical of that doctrine because it wasn't in line with the evolution of business. Because, as I said before, it's very difficult to often attribute the knowledge of lower levels of the company to those CEOs. I mean, they're so far removed often from the actual business that's being undertaken. And of course, with multinationals, the true directing mind of business was often unclear. Corporate might have a board, but it might have subcommittees, it might have different senior managers, there would be complex management structures, multiple subsidiaries. So who were the real directing minds and will? No one really knew. And often there's lots of delegated authority, and senior managers who did have those decision-making functions weren't considered to be the directing mind. Their job titles were very low level. They weren't board level. They weren't executives. They were perhaps a manager, but not with that directing mind and will, knowledge base and ability to make decisions on behalf of the overarching company. And also, as we've seen in lots of different types of areas of work and of roles, companies often were retaining the benefit of criminal conduct carried out by people just associated with the business. So you have agents, you have consultants. Of course, they're not employees, they're not part of the business, but often they were again making decisions on behalf of the business, but couldn't be attributed to being the directing mind and will. So, understandably, there was a decision to include in the ECCT a statutory route to attributing criminal liability under Section 196 of the ECCT. Now, it was passed. The actual act was passed very recently in December 2023, and immediately this doctrine came into force on 26th of December 2023. So it is already in force now, and I'll come on to later about the failure to prevent offence, which has not come into force yet, which is very important for corporates to understand because it will give time to change or do anything within your corporates to ensure that you comply with that law. So at the moment, this is the only element of the Act that is relevant to this talk that has come into force. So, as I say, the ECCT overhauls the common law position. It makes it easier, or arguably easier, we haven't seen the impact of it yet, but arguably easier to attribute liability to the corporate by providing that the actions of a much broader scope of individuals, including senior managers, when they're acting within the scope of their actual or apparent authority. Now, they will be now capable of binding the corporate in relation to relevant offences, and I'll again come on to those slightly later. So now it doesn't matter what their job title is, it's what are they actually doing? What decision-making ability do they have within the corporate? Or whether they're associated with the corporate and they're making those decisions on behalf of the corporate. And that will significantly lower the threshold for criminal liability and will enable, well, government believes it will enable prosecutors to increase the prosecutions, but reduce the ability for corporates to use these corporate complex management structures to conceal who the real decision makers are. And it will also level the playing field for business of all sizes. So not just smaller companies will be prosecuted, much bigger corporations will be capable of being prosecuted and potentially convicted for certain offences. So, crucial question: what is a senior manager? It's as I say on the slide there, it's one who plays a significant role in the making of decisions about how the whole or a substantial part of the activities of the organisation are to be managed or organised, or plays a significant role in the actual managing of those. So again, what does that really mean in practice? Well, whether an individual is a senior manager, it just depends on what they actually do in practice, not by their title, not by their job role. They don't necessarily need to be an employee. They could be a consultant, as I said before, an officer, or another third party meeting that criteria. And the government's impact assessment, so what they have to send and they have to look at the impact of an act before it is passed. What they stated in that impact assessment was that they will look at the roles and responsibilities within the organisation of a person, the level of managerial influence they may assert rather than their job title. Now, where's this come from? It's not a new concept necessarily, but it's been drawn from the Corporate Manslaughter and Corporate Homicide Act 2007, which is on the slide there. One thing I would say, it's like used in a slightly different way under the ECCT compared to the Corporate Manslaughter and Corporate Homicide Act. Under the ECCT, the senior manager needs to have committed the offence for the corporate to be found guilty, whereas under the Corporate Manslaughter Act, it's only where a senior management caused a substantial part of the breach. So it's slight differentiation there, but ultimately same definition of what a senior manager can be. What I should point out for those of you who are in the financial services sector, however, it is not the same definition as what a senior manager is under the senior managers and certification regime, which was brought into force post the Lehman Brothers collapse in 2008. And the senior managers regime covers bodies that only have ultimate responsibility for decision making in particular areas within financial services firms, whereas senior managers under the ECCT covers a much wider range. So if anyone has any queries about that, I can make a bit more of a distinction, but I'm conscious that not everyone on here is a financial services professional. So if anyone wants to speak about that later, please let me know. So what's in scope? Well, what organisations first, I suppose, is the best thing to talk about. Well, the changes really under the section 196 of the ECCT will apply to virtually all body corporates and partnerships, whether they're incorporated or formed within or outside of the UK. So really could be anybody depending on the different offences, which I'll again come on to slightly later. I said that this only applied to relevant offences, and these are described as economic crimes, and they are specified in the Schedule 12 of the ECCT. I've listed overarching. I can obviously again go into the specifics, but for example, under the theft offences, it's theft and false accounting. It's all of the offences under the Fraud Act 2006, Bribery Act offences, including being bribed and bribing, and various other offences, including actually Sanctions and Anti-Money Laundering Act 2018, the more recent act, so the regulations under those acts. So it's a very, very wide range of economic crimes. I should say, horizon scanning in the future, it is limited to economic crimes, but further reform is even being proposed now to extend that scope of Section 196 to all criminal offences by a senior manager. Now that's passing through Parliament at the moment with the Criminal Justice Bill 2023. It's only at the reporting stage in the House of Commons at the moment, but that is likely to face particular scrutiny, I think, in the House of Lords. This act faced very harsh scrutiny in the House of Lords, so I suspect it will be. I'm not sure whether that reform will come into pass, but it is a possibility that it could apply to all criminal offences, not just those specified in Schedule 12. Just a few more pieces of commentary on Schedule 12. It includes, as I said, the offence of being bribed, receiving a bribe under Section 2 of the Bribery Act. Whereas the corporate offence, which I'll come on to later, of failing to prevent bribery, is triggered by the offer of payment rather than the receipt. So Section 196 exposes organisations to corporate criminal liability where one of the senior managers receives a bribe. So that's a much wider scope, potentially, of the Bribery Act to apply as a result of the passing of the ECCT. So it's a really interesting development, actually, which perhaps not many people have noticed. It's a slight extension of that corporate criminal liability under the Bribery Act now. I should also mention, I do want to mention, it's not just those offences in Schedule 12, but also attempts, conspiracy, aiding, abetting, counselling, or procuring the commission of those offences. So it's not just those offences. It is a very wide amount of offences that could result in the corporate being facing liability. So that's major change for in the UK. What then are these new, or rather not new offences, these corporate criminal liabilities specifically could be committed by a corporate? Now, apologies, we're 14 years too late for me to be providing new information about the UK Bribery Act. So apologies if this is very well known to those on the call, on the webinar, but I think it's worthwhile just having a little bit of a refresher for those, and particularly those that perhaps aren't familiar with it. So the failure to prevent offences of the failure to prevent bribery is under Section 7 of the Bribery Act 2010. It makes it a corporate criminal offence when a corporate fails to prevent a person associated with the company, I'll come on to that in a second, from bribing another with the intent to secure business or gain commercial advantage for that corporate. Now on the slide, I've mentioned jurisdiction. I'll come on to a bit more detail about jurisdiction later. But just to say that the offence applies to all UK corporations or partnerships formed in the UK, irrespective of where it carries on its business. There does have to be a UK connection. Again, there's a slight difference to some of the other failure to prevent offences. But ultimately, that could be a sort of UK subsidiary here, where all of the other activity occurs elsewhere, completely overseas. That will provide sufficient jurisdiction for the UK to law enforcement to look into or prosecute or investigate, certainly, bribery overseas. So I'll come on to that in a bit more detail later. Now, Michael, in July, will be delving into this offence much more when he speaks at the compliance training event. But suffice to say that there is a defence where a corporate can demonstrate adequate procedures were in place to prevent an associated person from engaging in such conduct. Now, if a corporate doesn't have those procedures in place and bribery occurs, it may or it will commit an offence and could be prosecuted. And really, the penalties are incredibly serious for corporates. There's an unlimited fine, potentially, debarment from public contracts, confiscation and or compensation out of confiscation, serious crime prevention orders, deprivation order or financial reporting order, and of course, huge reputational costs as well. There are also corporates under the identification principle, as I mentioned before. Corporates can also commit the offence of bribing another person, receiving a bribe, or bribing foreign public official under the various subsections, so subsections 1, 2, and 6 of the Bribery Act. And of course, individuals can also be prosecuted for the same conduct. And there is also, under Section 14, senior managers can be prosecuted alongside corporate for consent and connivance with the corporate in committing corporate offences. Now, we haven't actually seen there's been lots of threats of prosecutions of individuals for this consent and connivance offence, but we haven't seen much by way of that section biting so much. But we might see more with the identification principle changes that I mentioned earlier. So that's failure to prevent bribery, whistle stop tour. I'll come on to jurisdiction in more detail later. What's the next failure to prevent offence? So this is the facilitation of tax evasion. And this is under sections 45 and 46 of the Criminal Finances Act 2017. Now, there are two offences. The first offence applies to all businesses wherever located if they are facilitated, or if in respect of, I should say, the facilitation of UK tax evasion. So if the tax evasion is of UK taxes and the corporate did not prevent the facilitation of those UK tax evasion, that UK tax evasion, then doesn't matter where that business is located. That is an offence that could be investigated and prosecuted in the UK. The second offence applies to businesses with a UK connection in respect of the facilitation of non-UK tax evasion. So this could be a UK corporate with a subsidiary in China which evades Chinese tax, for example. They could be carrying on a business or part of a business in the UK. So again, a Chinese parent company with a UK subsidiary branch where the Chinese parent fails to prevent Chinese tax evasion. Again, that would establish jurisdiction potentially. And with respect to the facilitation of the foreign tax evasion in the UK, a Chinese company with no UK presence that pays its suppliers in cash while in the UK, avoiding Chinese taxes, that also could establish jurisdiction. So there's lots of different ways that UK connection could be established with regard to this second offence, or even the first offence if it's the facilitation of UK tax evasion. The only thing I would say, and I've mentioned it on the slide here, is with respect to foreign tax evasion, there is a slight further hurdle, which is that the prosecution also needs to prove dual criminality, so that the tax evasion and the facilitation offences are offences both in the UK and in the country in which the offences were committed. So there is a slight further hurdle when it comes to the facilitation of foreign tax evasion, non-UK tax evasion. Now, there are two stages of these offences. So first of all, there has to be criminal tax evasion, not tax avoidance. It's very important. There are lots of tax avoidance schemes which are not evasion, but it has to be tax evasion. So that's something that might want to be argued at the time. It was an avoidance scheme rather than an evasive scheme. So criminal tax evasion must have taken place, and a person or entity who is associated with the business must have criminally facilitated that tax evasion whilst performing services for that business. So if somebody is acting in a personal capacity, they're personally evading tax evasion, they're not acting on behalf of the company, then this offence cannot be made out. But I suppose it's trying to catch individuals who are acting on behalf of a company in the supply chain. Perhaps they're paying their supplier or they're paying a contractor in cash, and that contractor or that supplier is avoiding making tax returns, and they're secretly funneling away those funds. That's what it's designed to protect against. So if somebody's doing that in a personal capacity, this offence wouldn't made out. Just on who are associated persons, they are defined as employees, agents, again, so not necessarily employees, and also slightly wider, persons who perform services for or on behalf of the business. So that could be, again, contractors that you're contracting, suppliers that you're supplying to, agents, intermediaries. So you have to, for this offence, be really conscious of your supply chain, very conscious of who you're working with, who you're operating with, because if they're acting in a capacity on behalf of the business and they're paying somebody in cash, paying a company in cash on your behalf, that could be sufficient to establish this offence. Now, where are the defences? There's always a defence. You will note a theme amongst these offences. There's always a defence of, in the Bribery Act, it was adequate procedures in place to prevent bribery. In this offence, or these offences rather, there's a defence of reasonable prevention procedures, so reasonable. And again, Michael will go into what is reasonable. So I just want to mention it today. But there is a differentiation between what's adequate, perhaps under the Bribery Act, and what's reasonable under this offence. Now, these offences really can affect all companies across all sectors. It really doesn't differentiate between one or the other. The idea is that His Majesty's, very conscious that we have now changed to the King rather than the Queen, but I'm still in the Queen mode. His Majesty's Revenue and Customs, HMRC, they wanted to ensure that businesses couldn't just simply ignore whether their customers or their supply chains were tax compliant. It's trying to ensure that those that engage in cross-border business pay large sums to consultants or customers or suppliers, engage in casual or itinerant labour and contractors, handle goods and services where there's organised fraud or organised crime risk. Where they're at high risk, they're very high risk at falling foul of that new legislation. And so I think they just wanted corporates to look at themselves, look at what their supply chains are doing, and actually think more about this. Now, we haven't seen much enforcement of this offence yet. Perhaps that's because corporate are getting very good as a result of the Bribery Act in looking at their internal policies and procedures, looking at their supply chains and seeing where are our weak points, where are our touch points on tax evasion or bribery or fraud, which I'll come on to later. But if you are at high risk, I would very much look into your supply chains and start thinking about this offence, because there's no enforcement yet, but I suspect that they are very keen on enforcing that very soon. The penalties, very similar to those under the Bribery Act, but they also include this 200% tax penalty on the tax due. And that's unlimited. That could be a huge amount of tax. So again, something to think about. So, third offence. This is the most recent offence that I wanted to talk about, and probably, in my view, the most wide-ranging, and it really is one of the biggest reforms of economic crime legislation in recent years. Now, I mentioned before that it won't come. This is the failure to prevent fraud offence. Sorry, I should say what it is rather than just saying it's a big reform. It's the failure to prevent fraud offence. Now, I mentioned earlier that the identification principle reform under the ECCT has come into a force already in December 2023. The failure to prevent fraud offence does not come in until 2025. And that's largely because of how important it is and how many corporates it will affect, not just in the UK, but those that have any touch points in the UK, even if they're based wholly overseas. So it's a really, really, really important reform that lots of corporates need to start thinking about. And as I say, expected to come into force in 2025. So this is under section 199 of the ECCT. The corporate will be liable. I put it on the slide because it's very important, but I will read it out. So apologies if you've already read it and you're very ahead of me. But the corporate will be liable where a specified fraud offence is committed by an associated person. I'll come on to what an associated person is in a second. Committed by an associated person for the organisation's benefit, where the organisation did not have reasonable fraud prevention procedures in place to prevent the fraud. Now, again, we are coming on to here a theme of, corporate liable or associated people, employees, agents, etc., for the organisation's benefits, commits an offence, either tax evasion, facilitation of tax evasion, bribery, or fraud, and there weren't those procedures in place to prevent that fraud. Now, I'll come on to the fraud offences later, but there are it's a huge reform in terms of how easily fraud is committed and how under, it doesn't matter whether the company's management ordered it or didn't order or knew about the fraud or was involved in the fraud. It's a huge, it could be huge in terms of how many ways that this offence could be made out. Associated person, as I mentioned on the slide, that's an employee, agents, subsidiaries, and again, it goes back to the same language that was used in the failure to prevent the facilitation of tax evasion offence. It's any person who performs services for the relevant organisation. So a huge number of types of person that can commit this offence, that may then cause the corporate to become liable for failing to prevent it. What I would say, there was a lot of debate about this offence because of how I mentioned right in the introduction that fraud is now 40 to 60% of the offences that are committed in this country alone. And I'm sure that statistic is translated worldwide. I'm sure fraud offences, particularly online, but more generally now, it's a huge problem in this country. And therefore, to ensure that corporates aren't falling foul of this legislation always, I mean, it could be a constant problem for different corporates. There was a lot of debate both at House of Commons level and at the House of Lords level about who should be, which corporates could be liable for this offence. And there was a concern that it would capture tiny corporates as well as the big corporates that it was actually trying to focus on, and that in order for those corporates to have to overhaul their systems, their policies, their procedures would be a huge undertaking, particularly for small law firms, small corporates. So the House of Lords, the House of Commons really introduced it, but the House of Lords acquiesced in this offence only applying, and I say this on the slide, only applying to what are termed large organisations. Those are those that meet two of the criteria I've set out on there. So more than 250 employees, more than £36 million in turnover, or more than 18 million in total assets. So two of those three, not all three, not one of those three, but two of those three. So it will really only apply to very large organizations. However, a very important factor which was raised during the debate, but ultimately no provision was inserted to change this impact of this insertion of this large organization definition. The offence applies to subsidiaries of parents if the entire group, including the parent and subsidiaries, meets the criteria. So say your company mainly is based in China, but it has a tiny subsidiary based in the UK, 2 employees, a million in turnover, a million in total assets, something of that nature. If the Chinese corporate itself, a parent company, has more than 250 employees, or more than 306, sorry, I keep saying 306, or more than 36 million in turnover, or more than 18 million in total assets, the entire parent group meets that criteria. So again, it is really important that you might think, oh, well, we've got a tiny UK subsidiary. It doesn't apply to us. It may do if your entire organisation meets 2 of those 3 criteria. That's really, really important to bear in mind. I will very shortly come into this, but the offence has significant extraterritorial reach, and it will be committed by overseas organisations where an employee or an associated person commits a relevant fraud offence under UK law or even targets UK victims. So importantly, you may not have any operations in the UK, but your company might target UK victims or that's the wrong way, target or market to the UK market. We're seeing this a lot with purely online crypto firms or purely online data-driven operations. They may not have any operations physically in the UK, but they market to UK individuals. And so somebody on behalf of the company commits a fraud against, and the UK individuals are victims of that fraud, then that could establish jurisdiction for the failing to prevent fraud offence. So all corporates really that have UK touch points need to start thinking about this offence, as well as the other offences, but particularly the new failure to prevent fraud offence. So I will now go on to the jurisdictional reach, a good segue into it. Can Chinese corporates be liable? Well, again, forgive me if I'm going over old ground for a lot of you, but I thought I'd go through each three of them just to see how different they might be, slightly different in terms of jurisdictional reach. So for the offences that could be criminally attributable to corporates as a result of the identification doctrine, so that's sections 1, section 2, section 6 of the Bribery Act 2010, where the bribery is committed, either receiving or paying a bribe in whole or in part in the UK, where the offence is committed in whole or part of the UK, the nationality or place of incorporation of the culprit is actually irrelevant. So where it's got that touch point of the actual offence of the UK, doesn't matter where the corporate is based. And so that corporate could be prosecuted, maybe even convicted, or have to enter into a deferred prosecution agreement in relation to that offence, depending on what is available to it. Additionally, criminal conduct committed by individuals or corporates with a close connection to the UK can also be found the offence in the UK. So that can be British citizens. We've had incidents where a completely overseas corporate had no connection to the UK apart from one of their directors was a British citizen. So that was capable. I mean, it didn't actually, in the end, come to anything, but that was a possibility that British citizen, that director of that corporate, could potentially be the finding of a criminal conduct committed by an individual with a close connection to the UK under the Bribery Act. Citizens of British overseas territories, so not just British citizens, but in terms of corporates, bodies incorporated under the law of any part of the UK, they're deemed to have a close connection to the UK, and they also may be prosecuted where the offence takes place outside the UK. So again, those that have subsidiaries in the UK, that is obviously deemed to have a close connection to the UK. And of course, foreign nationals who commit bribery offences while domiciled or habitually resident in the UK, that has also been a potential finding of jurisdiction. In terms of the failure to prevent offence, the Section 7 offence, once it's established that the commercial organisation carries on a business, either wholly or part of its business in the UK, regardless of where it's incorporated, if an associated person bribes another person or a foreign public official for its benefit, the corporate's benefit, the organisation may be guilty of the offence. So really it's establishing that the business it carries on its business or part of its business in the UK. So that is slightly different to the other failure to prevent fraud offences. There has to be a carrying on of business in the UK or part of the business in the UK to find jurisdiction for the failure to prevent bribery offence. It doesn't matter if the associated person, however, has no connection to the UK. It's just that the organisation does. So really, it doesn't really matter where the offence is taking place. If that commercial organisation where the associated person paid a bribe or received a bribe, that could found the failure to prevent bribery offence in the UK. So I mentioned it in the slide, but it's a sort of abstract theoretical case study. But a parent company in China whose agent is in Australia bribes an official in, say, Vietnam for the parent's benefit, so for the Chinese company's benefit, they could be prosecuted in the UK if they had a subsidiary in London, regardless of the fact that there was no UK nexus to the original parent company, the agent, the person who received the bribe, or the corporate that received the bribe. It just, because there is a commercial organisation carrying on a business in the UK, or part of its business in the UK, that could found jurisdiction. I've yet to see, I must admit, such an abstract example of that kind of jurisdictional basis, but again, it's theoretically possible. And certainly, I should mention that there has been a change in the head of the organisation, the director of the SFO, the Serious Fraud Office, more recently, to somebody who is a former Metropolitan Police Commissioner, or Deputy Commissioner rather. He's very keen on more enforcement, more investigations, whereas I think there has been a tendency to rely on things like the deferred prosecution agreements. I think we will see more aggressive enforcement action over the next few years. We're still at the early stages of the change in that director position, so we haven't seen the difference yet. But I think there's been a tendency to imagine that the UK is very much taking a step back from enforcement and investigations and prosecutions, and just relying on this deferred prosecution agreement, rather than pursuing prosecutions and convictions. But I think that will change. That's my view. I'm not sure. We'll see if that's come back to me in a few years' time, and we'll see if my prediction is correct. So that's bribery. Again, I appreciate I'm going very much into the high level elements. Michael will be very much going into the weeds of this, into the minutiae and the detail, when we have the training event in July. So if it's not clear now, hopefully it will be by the end of July. In terms of jurisdictional reach for the failure to prevent facilitation of tax evasion, as I said, that's under the Criminal Finances Act 2017. Now, it might just be helpful just to see how an organisation could become liable, and then we can look at jurisdiction on that. So a taxpayer commits a tax evasion offence. So this is either UK tax evasion offence or in overseas, foreign non-UK tax evasion. Then next step would be an associated person of the company, could be an individual, could be an entity, criminally facilitates the tax evasion offence of the original taxpayer, whilst acting in the capacity of an associated person to the company. So again, going back to what I said earlier, it can't be a personal tax evasion. The associated person is acting on behalf of the company, and they facilitate the tax evasion of another person, criminally facilitate. So that's it. So the tax evasion offence, criminal facilitation of that tax evasion offence on behalf of the company by an associated person. And then how does the corporate become liable? The company failed to prevent that associated person from committing that criminal facilitation. So they're the three steps. Oh, sorry. There we go. Going through these slides very quickly there. So in terms of jurisdiction then, so we've got the three steps. I mentioned there were two offences, the UK tax evasion offence, a facilitation offence, and the non-foreign tax evasion offence, if I can put it that way. If UK tax is involved, an organisation can be liable wherever it's formed or operating. So that's very important. It could be have no connection to the UK whatsoever, no subsidiary, not market to UK individuals, but a corporate overseas, an associated person on behalf of that pays cash to a supplier in the UK, perhaps, or even down the supply chain. Eventually, right at the end of that supply chain, there's this sort of UK connection, UK tax evasion offence. Then that organisation might be liable despite the fact they have no connection to the UK other than the UK tax evasion. Where foreign tax evasion is concerned, they will only be liable, a corporate will only be liable if it's formed under UK law, or, like the Bribery Act offence, carries on a business in whole or in part in the UK. So it's there has to be a bit more of a link there to enable the UK to prosecute a foreign tax evasion offence. Again, I also said the dual criminality needs to be there, both the foreign tax evasion and the facilitation must be an offence both in the UK and in the foreign jurisdiction. So it's I haven't seen yet, and I think it will be a very rare event for foreign tax evasion to be prosecuted in the UK. But certainly, if there's UK tax involved, that there might be jurisdiction issues if UK tax evasion has happened. So, on to finally, I think the more interesting, certainly for me from an academic perspective, and certainly I hope for you, will find it interesting. What is the jurisdictional reach of this new offence of failure to prevent fraud? Now, it's very, in one way, if you speak to different people, they will give you different answers here. So in one way, it's much wider than the failure to prevent bribery offence, particularly, because it can be committed by all large organisations and their subsidiaries, wherever incorporated or formed. Whereas the Bribery Act, as I mentioned before, only applies to companies and partnerships incorporated, formed, or carrying on business or part of a business in the UK. So again, it's much wider in that respect, that it can be committed wherever they are for failing to prevent fraud. However, in another respect, it's actually slightly narrower than the failure to prevent bribery offence. If a commercial organisation is within scope of the bribery offence, it can commit it even if the bribery has no UK nexus whatsoever. So if it's in the UK, wherever the offence is committed, doesn't matter if there's no other UK nexus. It's just if it's carrying on business in the UK. Failure to prevent, there has to be a UK nexus of the underlying fraud itself. So there's a slight narrowing there, as well as a slight wider. It's a slight nuance, but I hope that makes sense. So all organisations can commit the failure to prevent fraud offence wherever they are situated, but the offence has to have a connection to the UK. Whereas in the Bribery Act, it has to be a UK connected or UK carrying on business in the UK, but the offence can be committed anywhere else. There doesn't have to be any other UK touch points. I say it's narrower in terms of there has to be a connection to the UK for the underlying fraud offence, but actually, for those who are familiar with the Fraud Act offences under the Fraud Act 2006, they themselves have very broad jurisdictional scope, and it allows for any part of the criminal conduct to take place overseas. There just has to be a relevant event happening in the UK. So there could be meetings in the UK, but actually most of the other fraud offences that happen overseas, there has to be a sort of relevant event of the fraud happening in the UK to do that. So overseas employees may undertake a fraudulent act at an overseas company, but some of the victims are in the UK. Again, there's a wide scope to create the connection in the UK, but perhaps the damages are created here, or the victims are in the UK, or part of the agreement, the fraudulent agreement, or the part of the fraudulent misrepresentation occurred in the UK. There's lots of different ways that fraud can be made out from a UK jurisdictional perspective. So really, what does this mean? It means that companies and partnerships with UK operations or subsidiaries will be in scope, but also there could be, again, no connection to the UK. There could be no subsidiary if you target UK individuals, UK customers. If the damages are created in the UK, again, that the failure to prevent fraud offence can be made out. So really, again, I've said this many times already throughout this webinar, but really you need to think about where your UK touch points are. Do you have individuals that have lots of meetings in the UK? Do you have lots of operations in the UK? Do you market to UK victim? I keep saying victims. Do you market to UK individuals? Where are your UK touch points? Where could a fraud be reasonably made out in the UK for this offence to be made out? So it's something that I think a lot of corporates overseas are not thinking about yet, because they think, well, I don't have any involvement in the UK. We don't have a subsidiary in the UK. It doesn't matter if you don't have a subsidiary in the UK any longer. It matters if a fraudulent offence is made out in the UK, that your associated person, your agent, your consultant, your intermediary has committed a fraud, and therefore the organisation didn't do anything to prevent that fraud. So I've mentioned here adequate procedures, reasonable procedures. How do you prevent your corporate from becoming liable for these offences? Well, so what do you and your business need to do? Well, I feel a bit disingenuous and rather unhelpful and unfair on this call now, because I'd rather point you in the direction of Michael's talk, and the wonderful global compliance management masterclass with some incredible speakers from various different, Katana's there's some great other speakers that are going to be there, but particularly, obviously, I would be doing my firm and our senior partner a injustice if I didn't mention his talk particularly. He will be talking about what do you and your business need to do to avoid being found liable, and your corporate being found liable for one or more of these offences. He'll be talking about not just the UK, but also some learnings and some regulations that are coming in from the EU, which will also potentially affect your organisation and beyond. I think there is also we're going to be talking about some updates, both case law and legislative updates from the US, EU, UK, with case studies. So it won't just be my extremely boring theoretical aspects. It will be case studies that I think that will be really interesting for you to learn from. And just as an aside, I didn't want to completely avoid the content. Obviously, you will learn more about compliance culture. You'll be learning about what is or what is considered to be an adequate and reasonable procedure. You'll be learning about things that I'm sure you're already aware of, but your risk assessments, your proportionate and appropriate policies and procedures, your due diligence, reporting, training, monitoring, and review. So these are all things that we will be delving into by reference to case law, because again, so much theory around this. There's so much guidance, but what is this in practice? What does it mean in practice? So that's it from me. So see you in July. Me not, but Michael, and of course Robert and Li Ming will be there. We'll see you in November, because I'm very much looking forward to speaking about other topics in November. So that's it from me. So I'll take any questions.
Charlotte, thanks so much. This has been a really fascinating and informative presentation. I took lots of notes. We have some questions. I have some questions. So since I'm moderating, I'm going to ask my questions first. So for this, I have to confess that this was news to me. I was not aware of the ECCT, and I was wondering whether it's the expectation that this will now be a precedent-setting or influential new law, similar to, as I understand, the bribery law is considered to be the gold standard. And whereas the bribery law was not first, you had the FCPA in the US first, but the bribery law kind of expanded the concept of liability beyond what was covered in the FCPA, in my understanding. But I understand that the bribery law is considered to be the gold standard now, and is very influential. Is it anticipated that the ECCT will be considered a gold standard in the same way and be influential in the same way?
It's a really interesting question, because to my understanding, and forgive me, I'm sure people will correct me if I'm wrong, it is one of the first legislative provisions that is this failing to prevent fraud. It's the first time I've certainly heard of it, and it seemed to come on the legislative books very quickly. There was no real huge amounts of discussion beforehand, and I think it was created in order to tackle what I mentioned in the talk, which was this rise and meteoric rise of fraud in this country. And as I say, it's happening all around the world. So I do think it will be interesting to see whether other jurisdictions do follow the UK's lead in this. I haven't seen anything from the US or the EU that is complementary or similar to this proposal. It's now it was a proposal. It's now being enacted. I mean, it's still a proposal because it's not coming in force until 2025, and that is to enable corporates to really see where they need to change their compliance, where they need to look at their policies and procedures, and change that. But it will be really interesting to see whether it will become the gold standard. I mean, the one thing I think it was a shame that uh, they're only doing this for large organizations now, because I think this is a perennial problem, not just for large organizations, but smaller organizations as well. But I think what they wanted to do first was dip their toe, as it were, into how is this affecting large organizations, and how will it change their culture? How will it change their policies and procedures? And then maybe it will cascade down to more smaller organizations. But because it hasn't come into force yet, I'm not sure what the impact will be. Will it be like the facilitation of tax evasion offence, where it's almost introduced just to make corporates think, to think about how they might prevent fraud within their organisations to tackle this epidemic? Or is it really something to enforce? And really, is it going to be something that has teeth rather than more of a shield rather than a sword? So I think we will know more once we start seeing more enforcement coming into play. If there's a huge amount of enforcement, and it clearly there does need to be that gold standard, I think it will cascade out to other jurisdictions, and England will be the prototype, the trailblazer in that regard. Or is it just more about compliance culture? Let's shield fraud from happening, rather than being more of an enforcement tool.
In fact, while this is not an area of expertise, I have minimal familiarity with some of these principles. And it did seem to me that this concept of failure to prevent was an extension of this concept of adequate measures, which also relates, in my understanding, to the US federal sentencing guidelines on corporate criminal liability, which essentially defines when can a corporation claim that they are not liable for the acts of a rogue employee. And therefore,
Exactly.
you have to have a very robust compliance system in place, and it has to be conduct that is clearly outside of the permitted scope of activities, and it's well defined and well supported by a robust system, compliance system. It seems to me that failure to prevent is somewhat similar to that concept.
It's exactly right. Exactly. So I think I talked about this historically in the November, in the context of sort of data regulation, those sorts of things. You can never prevent an employee, an associated person, an agent, somebody you have no control over, to a degree sometimes, that they are of their own free will. You can never prevent somebody from doing something if they really want to do so. But as you say, it has to be, if you have a high risk agent operating in a high risk country where it is known that bribery or fraud is de rigueur, is a common concept. That's how the country operates, for example. Hopefully there will be fewer of those over the years, but there are those countries that do. I mean, I work a lot in Brazil, and any Brazilian would tell you that's how their country operates. That's how they operate. And so it's very difficult to take that away from people. So if you know that your agents are working in Brazil, you need to have a strategy, you need to have training, you need to have policies and procedures in place that all of your agents know it is not right to bribe an individual or a foreign public official in Brazil or any other country. And so it's all about managing your risk and ensuring, as you say, that there were these adequate and reasonable and proportionate policies in place to ensure that people aren't engaging in that conduct. But you can never prevent everybody. It's just exactly what you said. There is a range of criminality that could be prevented, but there are some that criminals are very inventive and think of new ways of doing things and obscuring payments of that nature. So as long as you've got your procedures and also it's not tokenistic. It's a very important point. You can't just have a policy and never enforce it and never tell anyone about it or never train anyone on it. You have to really make sure that that's what the adequacy is, that's what the reasonableness is of these procedures. You've implemented them, you regularly update them, you conduct your risk assessments to ensure that they are appropriate to the different areas of your business. It's that sort of thing. And as you say, exactly on those sentencing guidelines, and additionally in sort of deferred prosecution agreements, both in the US and in the UK, it's a big part of it. What are you doing to remediate this, to prevent this from happening again?
So you mentioned a couple things there about this culture. And I would say that in my 30 plus years in China now, that in the early days, what you would have is you would have a policy that was on paper only, and it was observed in the breach. But since the prosecution, and we can say now the failed prosecution of Meng Wanzhou, the CFO of Huawei,
Of
the
course.
level of attention paid to actual implementation of compliance management systems in Chinese companies, of course, increased dramatically. And when I talk to compliance professionals or advisors who are experts in this area, they say that it's been a terrific sea change. But one of the things that leads to is, of course, the presentation and the instruction that Michael will be giving at the training program, because they'll be going into that practicality part. But you're mentioning the deferred prosecution agreement, the DPA, and obviously in that whole backstory to the prosecution of Huawei and Meng Wanzhou, you had HSBC, which had just signed its own deferred prosecution agreement 3 to 6 weeks prior to the first articles appearing, which triggered the investigation on the part of HSBC. And then it was several years later when the DOJ was able to threaten HSBC with a revocation of their DPA because of other potential criminal conduct, that they were able to put pressure on HSBC to be able to provide all the information they had on Huawei.
Of course.
And then the DOJ took a different view on what happened there than what HSBC had done at the time. And so that's another way where there's some indirect exposure for Chinese companies.
Completely. No, absolutely. And there's a huge criticism, I think still in the US, but certainly in the UK, of deferred prosecution agreements, because ultimately a corporate is what they want to do is completely save their own skin, and they have no qualms about whoever or whomever they involve in that deferred prosecution agreement. So they can accuse individuals of obscene amount. I mean, obviously it has to be backed up slightly by evidence, of course, but we act for a lot of individuals who are being accused without any ability to challenge the underlying factual matrix of that deferred prosecution agreement, the reason why HSBC enters into it, or the basis upon which they're entering into it, because it's completely behind closed doors unless you're involved in the matter. So we have for a lot of individuals who are being accused in these deferred prosecution agreements of heinous conduct, of being the main protagonists in this conduct without any recourse. And then the corporate agrees to this deferred prosecution agreement, it remedies its compliance culture, it moves on. But the impact that can have for other corporates, the impact it can have for individuals is huge. And that's the real criticism of deferred prosecution agreements, and particularly in the UK. And there's been a big criticism of the previous organisation, the head of the organisation, the director of the SFO, Lisa Rozovsky, where it seems to be the aim of the Serious Fraud Office to enter into a deferred prosecution agreement, get the money, and just move on and not pursue others. It shouldn't be about money. It should be actually getting to the truth of the matter. And you can see now fewer corporates entering into those deferred prosecution agreements, because ultimately, why would you admit to something if the individuals haven't been prosecuted, if the individuals haven't been found to be liable or convicted? You would want to wait and see whether the corporate is actually liable, whether those directing mind and will are actually being prosecuted for that before committing to something. So it's a huge area of criticism at the moment for the UK, and I think the DOJ has been also similarly criticised for not pursuing them in an open and transparent and correct manner.
So I have an observation and a question about deferred prosecution agreements. One, again, to the Meng Wanzhou case. Again, I'm not the expert. I haven't read a lot of deferred prosecution agreements. I've read several, and they all seem to follow a similar pattern. And they all had certain statements of fact that were agreed that if true,
Correct.
and if the DPA failed, then there would be a basis for actually finding of guilt on the part of the corporate. But when I looked at the Meng Wanzhou DPA, I saw the most anodyne, unimpressive statement of facts where there was really, she essentially, and I'm simplifying this a bit, but she is essentially acknowledged she was the CFO of Huawei. Huawei did business. That was about it.
Exactly.
That's my observation.
But this is the big criticism. I mean, and if you look at all of the UK ones, it's very similar. I mean, there's no substance to them to a degree, and then the corporates effectively, I mean, it's not admitting guilt. That's the whole purpose of them. But you're basically agreeing statements of fact that might have huge ramifications for an individual or huge ramifications for another corporate, when there's no testing of that in a court of law, and there's no testing of the evidence. So it's almost like an acceptance of something just to push it away and avoid reputational ramifications by agreeing to this, paying a sum of money and moving on. That shouldn't be right. It should be, what's the evidence here? What's the evidence of the individual involvement? What's the evidence of the corporate involvement? And go from there. I think that's the difficulty, is corporates are too keen to move on and just pay the money, take the fine, and move on.
Because when it's a fine and it's only an economic financial penalty, that is not much different than civil liability.
That's exactly right. And that's it. And then the whole concept is that there's no admission of guilt. It's just we accept that something has happened here. Let's move on.
So my question, actually, now I realize I have two questions. One, you said you referred to a deferred prosecution agreement only in one context here, and I had that for failure to prevent bribery, but not for the others. And then the other question is related to a deferred prosecution agreement. As I said, in the limited number of US DPAs that I've read, very similar pattern in terms of the remedial efforts to be made, but there was also a very common element of an appointment of a court-approved monitor. Is that also typical?
Really, so just on your first point, so the deferred prosecution agreements are available for all of the failure to prevent failure to prevent offences. So all three of them, they are available. Obviously, there have been more in terms of the Bribery Act, but still only 12, 13 or so, not that many since 2010. There've been none. As I said, the enforcement of the facilitation of tax evasion offence, there's been very, very limited enforcement of that. Now, whether that's just because HMRC are very slow in acting more generally, or whether actually it's just more, as I said before, the idea of trying to prevent it rather than enforcing it, that might be another example. And of course, we haven't seen any deferred prosecution agreements yet in relation to the new offence, because it hasn't properly come into force yet. So yes, they are available for all three. In relation to your second, and forgive me, I'm now deferred prosecution agreement in the US.
Monitor, whether there was
Monitorship, yes. There is the facility and possibility to have monitorships, and in a similar vein to the DOJ. They are on, I would say, on a less grandiose scale. I mean, you saw so many of the monitorships in the context of the Lava Jato, the car wash in Brazil, the big monitorships over there, like Odebrecht, after their deferred prosecution agreement. They were huge, looking into the corporate as a whole. I would say it's on a less grandiose scale. So you will have somebody monitoring an individual, usually almost like a mediator, looking at monitoring that they are remediating the steps that are um, they've promised under the deferred prosecution agreement, um, they have been less common, I would say, in deferred prosecution agreements. Here, it's more a report by the corporate that they have done what they have promised, and it's more looking into that from a prosecutorial standpoint. But certainly, the facility is available, and in some of the more recent, actually more less of the deferred prosecution agreements, actually in some of the convictions that have been secured, some of the guilty pleas, there have been issues, there have been monitorships that have been organised to ensure that they are remediating, not just taking the money, taking the hit and paying the fine. They are remediating what they've done.
Yeah, and actually, just again going back to the one case that I have looked
No, no.
into closely, HSBC was hit with an almost 2 billion US dollar fine and divestiture, DPA, and they had a very high profile monitor put in place. And in that context, where they had the highest of sensitivity levels that you can imagine, within weeks, that's when those first reports came out about the conduct, which was alleged on the part of Huawei, which led to this whole eventual prosecution.
Yeah.
And with
Well, I
that,
think,
in that context, is yet someone who had the highest of scrutiny would be applied by someone who is independent, very high profile, and they still looked at it and said, we're okay. But then a few years later, the DOJ, and I think in a politicized way, took a different view.
yeah, no, absolutely. And I think it's, I think monitorships are an interesting, as again, it depends on what they're looking at. So it depends on how much the corporate wants to give leeway to that monitoring. It depends on how much the court has ordered that monitor to look at all of the operations or only a siloed section of the operations. Because I think we've certainly seen in the past corporates being able to pull the wool over the eyes of the monitor in a certain degree. But as you say, sometimes these things still come out in some way, shape, or form. So it's really, really, it's still a developing area, which is unbelievable, really, talking about things that happened 14 years ago. But each DPA is very different. Some are very minimal. I mean, the one that we were involved in relatively recently was literally a payment of a fine, but that was the circumstances of the case. The entity that was alleged to have paid the bribe, that was a very siloed entity that had been sold. It was no longer part of the business, which is quite interesting, therefore, that they just said, oh, well, you don't need to do any remediation. The rest of your business is fine. It very much is fact specific. Whereas if it's entrenched in the compliance culture to pay bribes, perhaps the monitorship would have been needed to ensure that the entire business is remediating, is overhauling its systems and policies and procedures, rather than just a tiny rogue element that perhaps could be sold, could be siphoned off from the rest of the business. So it's very fact specific.
So we did have another question. We had several questions, some of which you'd already responded to in this presentation, and others we are leaving for Michael during
Yes.
his training. But one was this concept of dealing with agents or third parties in the supply chain, or I guess it could be in the sales channels as well. I mean, is there any further guidance that you would just give as a high level observation about
It's a
how to
really
deal
good
with
point. It's a good point. So I guess proximity is a big point. I suspect that lots of people are thinking about. You have an agent that directly acts on behalf of the company. I mean, that would more likely be considered to be, I mean, it's an obvious point, it will be more likely to be considered an associated person, a corporate directly asking an agent to do something, act on their behalf. What do you say? How is there a company that is an associated, if it's 10 links down the chain and it's an agent on behalf of a company right down to the chain? Well, again, it is very fact specific. I mean, I think there is an element of the further away you get from the corporate itself, the less likely it may be considered an associated person. But again, you've got to really see where what the directions are and what the instructions are of the original corporation as to whether this associated person, 10th down the chain, who's an agent on behalf of this corporate, is acting on behalf of or of the company ultimately. And it might be that might be the way that your supply chain always operates. So you know that this person down the chain is ultimately an associated person with the company because they're acting on your company's behalf. Yes, 10 down the chain, but the economic benefit ultimately comes back to your corporation. I suppose if it's an unusual arrangement, if there's no acknowledgement that that corporate would ever use an agent normally, and then they suddenly use an agent in Iran, and it's a very high risk jurisdiction. They didn't tell you that they were getting their supply, their contracts from that person in Iran. That would be a situation where you would argue, how is that person operating as an associate of the company? That's really where I would start to break the chain of the link. I should say, though, there is more guidance coming out on the failure to prevent fraud offence, which I can obviously share amongst the network, on what might be considered an associated person, where there might be differences of opinion of what that could be. That might help narrow it down a little bit more as to where we see the associated person being defined by government, defined by the legislative.
But we do see in all areas of compliance, we see more and more responsibility to do this type of due diligence on your supply chain and on your sales channels. The corporate is responsible up and down the chain more and more. We just had a presentation last Saturday as part of one of our Gonkai, our free programs, where our friends at the Heuking firm, they talked about the supply chain due diligence requirements under the German Act. And of course, we see a lot of these things in a lot of different contexts. That's a trend in my observation.
Completely. And I think, particularly with things like modern slavery, that's becoming more of an idea. There are lots of different you need to know where your ESG, that's a huge thing. Are your suppliers green? Are they claiming to be green? What are your suppliers doing? So I think gradually there will come a point where you can't argue this proximity argument necessarily, because you have to know for various different pieces of legislation or pieces of regulation, you have to know where your supply is coming from. You have to know who you're contracting with. You have to know where those are. So I think gradually, I totally agree with you that there will become a point we can't argue that proximity argument. I just think at the moment there's still some uncertainty. If there is a rogue person down here in the chain, you're here. Do you know, or should you know? Goes back to that preventative and knowing your supply chain, which I totally agree. If that's the way the market's going, that's certainly what will be argued in future years to come. You can't argue that.
We see that with export controls and secondary sanctions. That's already the full
absolutely
chain.
Absolutely. So yes, it's something that is know who you're working with is a crucial key takeaway.
All right, well, this has been a great presentation and conversation, and I know that there are a lot of other things that others would like to ask. We had some more questions, but I'm going to save those because they do relate to the presentation in July.
Yes.
But also, I had some other questions about extraterritoriality. Obviously, that's a very sensitive topic, and it has some geopolitical elements and aspects to it, of course, because the more attenuated or as farther it's removed from having a real connection, the more it's going to be in dispute and going to create some geopolitical tensions. But so far, a lot of the principles that you outlined, I think, make sense. And we do see that, for example, I think online sales is a very clear example. If you have customers, you're marketing there, and if you have conduct which harms individuals in that jurisdiction, well, then you're going to have some liability. That's clear. I think there can be some cases where you can have an entity that is a small entity as part of a large corporate group that is in the UK in your example or in your case, but it's so remote to all of the other activity that maybe it won't be applied. But then you have the US, which takes the position if you have US dollars and
exactly.
US financial banking system, or if you have emails that go across servers in the US, then they have jurisdiction. That is, of course, a very aggressive position. But I think
Completely.
there is a rational basis for extraterritoriality in certain cases, and it's much more problematic in other cases. And I think that's the way it's probably going to always be.
Completely. And I think in the UK we always look to the US. I think we constantly think the US is slightly, their extraterritoriality is very aggressive. I think we would like to emulate that, but I think there's a recognition perhaps that the UK is less positioned less centrally than perhaps it once was, and the US perhaps feels like it needs to be a bit more patriarchal about about the way that it operates across the world. Perhaps that will diminish as well in due course, but I think the UK recognizes our position in the world.
All right. Well, thanks very much. Appreciate all for joining us. And
Thank
this
you.
will be made available as a recording. And I'm sure we'll take some of these and put them out over our social media. So thanks again, Charlotte. And we look forward to seeing you in November. And we'll see Michael in July and November.
Great. Thank you, Robert. And thank you, everyone. Thank you for SIPAC for inviting me. And welcome to everyone. Thank you.
All right. Good night.